Hello there. Welcome to this session of the 38th Annual Conference of ECTA in this beautiful city of Edinburgh, capital of Scotland. The title of the conference is New Horizons Through the Highland Haze. And to start with, this workshop is dedicated to a topic that is an example of how IP and ourselves, IP practitioners, have to adapt to new horizons, constructing evidence based on disclosure on the internet. Nearly 15 years ago, Professor Foster Wallace, in the graduation ceremony of Kenyon University in Ohio, started his speech with the following story. There are these two young fish swimming along, and they happen to meet an older fish swimming the other way, who nods at them and says, "Morning, boys, how's the water?" And the two young fish swim on for a bit, and eventually one of them looks over at the other and goes, "What the hell is water?" Professor Wallace said to his students, "I ask you to think about fish and water and to put on hold for a few minutes your skepticism concerning the value of what results absolutely obvious." We do not realize sometimes how the digital revolution has changed our lives. The possibility to access to millions of documents and information in a few seconds has changed the traditional way of transmitting information, like, for example, through books, journals, TV, radio, etc. On the other hand, emails and social media have also changed how people communicate information. And this has a very important influence on IP and on our daily work. So today we are going to spend some time thinking about fish and water. Look, for example, about designs. You know that designs, to be valid, they require to be novel. But nowadays, most of the disclosures take place on the internet or conducted through email communications or social media, and they may destroy novelty of a design. However, how must we provide this information about these disclosures? Because we need to show the date when the disclosure took place, who made the disclosure, to be a valid evidence. On the other hand, there is more and more use of trademarks on the internet. How evidence of this use has to be produced? What about evidence about prior use of a trademark? The common use of a term to designate goods and services, and thus the lack of distinctiveness of a word that could not constitute a valid trademark. What about digitally stored documents in discovery processes? What about probative value of information in Wikipedia? Or what about these internet archive systems like Wayback Machine? To deal with all these issues, we have the privilege and honor to have what I call a dream team of 5 experts that will explain us how these matters are being considered from different angles and from different geographic areas. I will introduce all of them now in order to avoid interruption of their presentations. So, to start with, the first speaker will be Sergio Rizzo, here at my right. Sergio has a law degree from the University of Bologna and a postgraduate specialization in European law and economics by the University of Perugia, and another one on finance and business development by the University of Bologna. He practices in Alicante in the firm Dauden. He's a member of the ECTA Design and EUIPO Link committees, as well as a member of the board of the IP section of the Alicante Bar Association and of the Spanish Association of Intellectual Property Attorneys. He is a member of the SIPE 10. SIPE means Convergence Program from EWIPO that deals with criteria for assessing disclosure of designs on Internet. So he is the ideal person to explain to us the situation about this topic in the European Union. The second speaker will give us a perspective from the US. For that, we have the privilege and honor to count with Robert W. Sakoff. Bob, he's here on my right. Bob attended the University of Notre Dame and the Northwestern University School of Law. He has served as chair of the American Bar Association on IP law. He has been president of the EAPPI US group, has been a member of the board of INTA and of the American Intellectual Property Law Association, APLA, and has been advisor to the US delegation on the Trademark Law Treaty. Bob has received the EAPPI Award of Merit. Only 8 US lawyers have received this award so far. And on this year, he has received from the District Columbia Bar's Champion of IP Award for his career contributions to the IP law field. Bob is a partner of the reputed US IP firm Patishall, McAuliffe, Newbury, Hilliard, Harrelson in Chicago. The third speaker will give us an update of how this topic is considered in Japan. For that, we have the honor and privilege to have a very prestigious Japanese trademark lawyer. She is Mrs. Nami Togawa. Nami is a leading trademark lawyer in Japan with an experience of 25 years. Nami has been the chair of the Japanese group of the Asian Patent Attorneys Association, APIA Anti-Counterfeiting Committee, and of the Japanese group of APPI for Geographical Indications Committee. She is a regular lecturer on IP matters like the Japan Intellectual Property Association. Nami is a partner of the prestigious Japanese IP firm Seiba Patent and Law in Tokyo and manager of its trademark department. The fourth speaker will be Mirza Hurtado Rivas on the far right. She will give us the perspective from industry, very important. Mirza leads the trademarks, domain names, and copyright department of Novartis International AG. She has an executive master on international and European business law from the University of St. Gallen, a master on advanced international studies from the Diplomatic Academy and University of Vienna, and a bilingual law degree, German-French, from the University Miséricorde in Freiburg. Mirza is the chair of the EWIPO-WIPO DIECTA WIPO Link Committee. And last but not least, the first speaker, we have the privilege and honor to have the Honorary Lady Wolf, Sarah Pointel-Labutte Wolf, Queen's Counsel, Senator of College of Justice of the Supreme Court of Scotland. Sarah was educated at Dartmouth College in the United States. After undertaking postgraduate studies at Balliol College, Oxford, she emigrated to the UK and received an LLB from the University of Edinburgh. She called to the bar in 1994. She took silk in 2008 and practiced principally in commercial and public law. Appointments while in practice at the bar included as standing junior counsel to the Department of Trade and Industry and its successor departments from 1996 to 2008, and as senior counsel, one of the UK-appointed expert members of the CCEB expert group on European insurance contract law from 2013 to 2014. She was elevated to the bench in 2014, and she is the first woman to be appointed to the Commercial Court, where she now sits as one of the specialist commercial judges. Lady Wolf will explain to us how disclosures on the Internet and other digital media are taken into consideration by the Scottish courts. With this introduction of my dream team, I give now the floor to the protagonists of this workshop. So I kindly ask Sergio to start. Sergio?
So thank you, Luis Alfonso, for your kind introduction. Well, ladies and gentlemen, it's a pleasure to be here with you today. I've been asked to give a short review of the EU perspective in relation to the proof of disclosure of designs on the internet. Essentially because, as already mentioned by Luis Alfonso, I'm currently representing ECTA in the convergence project CP10, launched by the UIPO in 2017, with the objective to identify criteria and provide a recommendation for assessing disclosure of designs on the internet. So, based on the current status of the CP10, which is currently underway, I will present an overview of the principle for assessing such disclosure on the internet. My presentation will focus on the most relevant sources of disclosure on the internet, and I'll provide some guidance on how to establish the relevant date of disclosure. I will also give some examples of best practices on how to present the evidence obtained from the internet. So now that you're aware of the overview, let's briefly look at the background. As I just told you, the CP10 was launched a couple of years ago. The working group was composed of representatives from the national offices, the UIPO, User Association, and European Patent Office, has worked closely to prepare, to elaborate, and agree on a set of recommendations for assessing disclosure of designs on the internet. And we base our discussion on the existing case law and best practices, taking into account the feedback from the different stakeholders. And now the draft of the common practice is almost ready and will be presented at the next plenary meeting this September in Alicante. Anyway, as a preliminary conclusion, it's important to point out that in principle, the criteria applied when assessing evidence obtained from the internet is no stricter than when evaluating other forms of evidence. For instance, in this relatively recent decision, the Board of Appeal considered that the documents and information obtained from the internet must be examined, of course, with a critical approach, but it would be incorrect to dismiss them as such, just because of their non-material nature. However, there is always however, when relying on evidence disclosed on the internet, it's crucial that the source of disclosure, the representation of the design, and the relevant date are properly identified in the evidence submitted. I'll start from the most relevant source of disclosure. It's commonly accepted that a design can be disclosed in any possible source, worldwide, including the internet. And the most common sources of disclosure of a design are website, apps, email, and file sharing. I'll first mention websites. Well, it's well known that there are many kinds of websites, each specializing in a particular content or use, private, corporate, institutional, etc. But for the purpose of this presentation, the analysis will focus on three kinds of websites: e-commerce platforms, online database, and social media, given their frequency of use. Nevertheless, the same consideration may be applied to the other kind of websites not specifically addressed here. Likewise, a considerable part of the online activity entails the use of apps. In general, the same rules governing the disclosure on website can equally be applied to apps, because websites and apps usually provide the same relevant content in a relatively similar manner. In fact, the main difference between websites and apps is not the content itself, but the process and issues when extracting the relevant information, as disclosure of design on apps may have certain specificities, such as those displayed in this slide. Emails. Email can be another source of disclosure for the sign on the internet. It's true that traditionally, an email is perceived as private correspondence. Nevertheless, emails are also widely used in e-commerce. And an email which aims to commercially promote a product cannot be classified as private correspondence. Take the case of mass emails sent by online retailers to end user to offer and promote their product. They're not private correspondence. Finally, I'd like to mention file sharing. As a general rule, making a design available on a file sharing platform will be considered as disclosure. Peer-to-peer and file hosting are similar file sharing services, as they both imply the upload of a document, which is the file containing the design, and which is made available to user on the file sharing platform. Therefore, when assessing disclosure of designs through file sharing, two key aspects must be taken into consideration. The first one, of course, is the connection between the file containing the design, the disclosed design, and the file's indexing reference in the file sharing platform. And the second one, which is connected to the first one, is the establishment of the relevant date. And my next point covers precisely the issue of how to establish the relevant date of disclosure. Because the nature of the internet can make it difficult to establish the actual date on which information has been made available to the public. For instance, not all web pages mention when they were published. And websites are frequently updated and do not display records which enable the public, including the examiner, to establish precisely what was disclosed and when. Having said this, there are essentially three ways to establish the relevant date of disclosure for the site. Dates given by search engines and website archiving services, computer-generated timestamp information, and forensic software tools. Well, caution. Indexing dates can be of some use when establishing the relevant date of disclosure. Several search engines, such as Google in this case, allow users to filter results by date. Search results may constitute a preliminary indication that a design was available online on a certain date. However, search results should always be verified by taking further steps, such as entering the corresponding website listed as a result and confirm the date of disclosure. More in general, such kind of tools must be used with caution because, for instance, web search engine cache services only retain the most recent web version of a website. On the contrary, web archiving services, such as Wayback Machine, do store several versions of the website as they looked on different dates. So the most prominent of such services is the so-called and now famous Wayback Machine. The archive websites are saved as capture or snapshots of how they looked at a certain point of time. And when you enter the website address, in this case is oamieuropa.eu, Wayback Machine displays all the snapshots or capture available. So this system has the advantage of avoiding information from being lost when the website is updated. Let me illustrate this with an example of the homepage of the EU IPO in 2006. So now we can retrieve such information. We can see how the homepage looked several years ago through the Wayback Machine, which is commonly accepted at least before the EU IPO. So you can see there the date. However, there is always a however. Also, web archiving services have certain limitations. By way of example, such services may have difficulties to access password-protected websites, such as social media, and website owner can request to block such services from saving contents version of their website, and can also request the removal of such contents. Moreover, it's important to point out that a web page is not archived every time it's updated. Rather, it's archived only when crawlers visit the page, which in turn depends on the web page popularity. As a result, a global analysis of such items of evidence implies that they should always be corroborated by additional evidence as established by the Board of Appeal of the UIPO in the decision mentioned in this slide. So, electronic timestamp. Electronic timestamps are the second way to demonstrate that a certain design was available or disclosed at a certain point in time. In practice, electronic timestamps are used as a precautionary measure to secure information contained in a screenshot or printout, regardless the possibility of a later removal of the content from the website. As you can see in this example, when a timestamp is requested for a specific website, the timestamping service will provide a certificate verifying the timestamped content, such as the URL, the design, the dates, etc., or related to that website at the moment it was timestamped. And as you can see here, the PDF certificate, digitally signed and timestamped, shows the content visible on a specific website at a specific moment. I don't know if you can see all the details, but trust me. Finally, we can't ignore that the information concerning the relevant date is sometimes embedded in images, video, or programming used to create a website, but is not visible at first sight in the web page. And forensic tool may be used to acquire such metadata. Forensic tool may also be used to monitor the activity on a social media site, or even to capture events happening in a live environment. Nevertheless, it's important to provide full information about the tool used and how the information was extracted. And now that we have seen the boring part, I mean, the most important source of disclosure and how to establish the relevant date, it's time to give some practical example of best practices on how to present the evidence obtained from the internet. What you should take away from this slide is that reliability of the information obtained from the internet is assumed, unless there is a reasonable doubt to presume otherwise. Nevertheless, it should always be kept in mind that the event of disclosure cannot be proved by means of supposition or probabilities, but must be demonstrated with solid and objective evidence. Therefore, in principle, the event of disclosure can be established by any means able to prove it. However, I'd like to draw your attention on the most widely used means for providing such evidence. Printouts and screenshots are the most common ones. They should contain all this information, the source, information about the relevant date, and the reproduction of the design. And when such information is not entirely included in the evidence submitted, then additional evidence shall be submitted. For instance, if the date in the relevant post, including the image of the design, is missing, then comments or reviews made by users of a social media platform can provide this additional evidence. I'd like to share now some examples to demonstrate that there may be a challenge here for all of us. In this first example, the source can be found here in the URL, is the European office. And also, we can also clearly see the design and the printing date here. Nevertheless, in relation to printout, a screenshot is crucial to distinguish between the printing date and the date of disclosure, which is not always the same. The printing date will be assumed as the date of disclosure unless an earlier date can be established from the URL, the content of the document itself, or any other evidence. In this case, we can see the printing date is December 2018, but another available date for the public is indicated in the actual content of the document, March 2017. So in this case, the date of disclosure will be March 2017. Now let's consider that in order to establish the date of disclosure, an exact date should be provided. Nevertheless, also a date in a relative format, like here, 1 year ago, day, weeks, months ago, like in many social media platforms, can be used to establish the relevant date of disclosure. In this example, we can assume that this modern outdoor chair has been disclosed 1 year before the printing date. That is around May 2018. Another concern is that a screenshot or printout may show several designs. And for the purpose of disclosure, the exact design referred to must be clearly indicated in the evidence submitted, using arrows, boundaries, like in this case, etc. Nevertheless, it's important to stress that the relevant information, the date, design, and the source, must be apparent from the screenshot or printout themselves. Cannot be added or changed manually, and we see it several times in the other party submission. And so when a screenshot is directly included in the text of submission with addition boundaries, arrows for illustrative purposes, it's recommended to provide the original version and an altered version as a separate attachment. Also, care must be taken when printing a page that the source, the URL, is fully visible in the evidence submitted. Now, turning to e-commerce platform. It's well known that online retailers provide information, very useful information, concerning the relevant date of disclosure of a design. For instance, the date on which the product was first available for sale, in this case, September 2017, or even the date the product was first sold. And this information is very useful when proving the date of disclosure. Also, when, like in Amazon, a unique identifier number is linked to a product, such information is also very useful to corroborate the date of disclosure of a design. And it's also recommended to check and include the comments, reviews made by users of the social media platform, e-commerce platform, etc., as they may strongly corroborate the date of disclosure of a design. Concerning online databases, just to point out that if a design is published on a database managed by a public authority, is considered as disclosure, normally 100%. On the contrary, if the design has been published on a private database, normally the usual rules governing disclosure on the general kind of website are applicable. In this example, you can see the different dates usually indicated in the design view, for instance. And in this case, the date of publication will be the relevant date for disclosure of the design, not the application date. Social media sites can also be used and are frequently used to prove disclosure of design on the internet. In terms of the source, it could be beneficial to include information about the social media platform where the information is extracted, indicated purpose and main characteristics. And in terms of illustrating the date of disclosure, normally the date of upload of the post or the video on YouTube is considered to be the date of disclosure. But as I just told you, also comments and reviews made by user on the social media platform, etc., can be very useful to demonstrate the date of disclosure. And when the design disclosed in a video, I would recommend to submit the full video. I hope it's not a movie, but again, you should submit the full video, and if it's a large video, also the exact moment when the design appears in the video should be indicated. And I would also recommend to provide information about the source, the URL, the social media where the video is being published. Let me illustrate this by quoting a decision of the Board of Appeal of the UIPO, which considers date of disclosure the date of upload of this video on YouTube, considering that this date cannot be modified by user. I'm not an IT specialist. I don't know if possible to modify, but the court accepted it, the Board of Appeal, sorry. Metadata. Additional evidence of disclosure of design can be constructed through the analysis of metadata, normally embedded in images, video, etc. There are different ways to obtain metadata, so it's recommended to provide full information explaining how the metadata was extracted and from which source it was taken. Because the image can be extracted from a camera, from internet, for whenever. And also the kind of tools, forensic tools, used to extract such information give different results. On the contrary, internet links, URL address, hyperlinks, etc., normally per se are not considered as sufficient evidence of disclosure of a design, essentially because the web page that can be found following a certain link can be modified, closed, amended over time, or can lead to the visualization of different design, not just one design. And finally, concerning statements in writing, such as sworn and affirmed affidavits, testifying the existence of a specific content on the internet, they are not considered normally as sufficient evidence of disclosure of a design, especially when the affidavit submitted is made by an interested person. So in this case, it's always recommended to submit additional information, such as screenshot or printout, to prove the event of disclosure of a design. And that brings us to the end of my presentation. I'd like the rest of colleagues to speak, so I finish up by saying thank you for your attention.
Thank you very much, Sergio, for your very clear presentation. I inform you that we will take questions at the end of the session, well, at the end of this session.